Hello, I'm attorney Chris Morgan. Hands down, the #1 question I get from clients out of the gate. Do I really need a trust? Why can't I just use a simple will? In order to understand why most of my clients choose a living trust over the will, we need to get some terms out of the way. First, probate. Probate is a court, just like criminal court, family court, or civil court. The probate judge has one job, and that is to assign new owners to anything that does not have a legal owner when someone dies. So think about the things that you own: a house, a bank account, a car, your pets, and even your kids, because you are their legal guardian. If you pass away, probate is the default method for finding your stuff a new home. A will is a letter to the probate judge. It tells the judge 3 things. It tells the court who you want to name as your executor or personal representative, where you want the judge to send your stuff, who are your heirs, and then who do you want the judge to appoint as the guardian for your minor children. A will does not skip probate. In fact, a will is designed for probate. If you don't have a will, the judge just applies the default provisions found in Utah's probate code. It's important to note here that some things automatically have owners when someone dies. For example, you may already have a beneficiary on your bank account or your life insurance. Your will and the probate court, therefore, have 0 effect on these because you've already designated an owner for when you pass away. This can create a conflict, though, if your will says, I want this to go to one person, but your beneficiary designation says something else. A trust, a living trust, on the other hand, is a management contract. It says, in effect, I own stuff, and I'm putting a manager in charge of my stuff in the event I become incapacitated or I pass away. The trust is basically a rule book on how you want things handled in the event of a major emergency. When set up correctly, the trust is either named as the owner or the beneficiary on your property and accounts, so that if something happens to you, all of your stuff has an owner, the same owner, and probate has nothing to do with it. Unlike a will, a living trust lets you make the rules for your own estate. For example, you can put stipulations on how someone suffering from addiction accesses their inheritance or doesn't access it. You can put stipulations on how your money is spent on your own care if you became sick or incapacitated. Well-written rules make a good estate plan, which results in less guesswork, less family conflict, and more independence for you. To get more information on how a trust can help you, please feel free to give me a call. I do not charge to chat. I'm not pushy, and I try to be helpful. Thanks so much.